Attorney Lulu, do we really have to sit through all the technicalities, you know, the stipulation, the document sharing, the evidence marking, in an impeachment trial?
In this kind of contest where the respondent or the defense is unwilling to submit or to give in to any of the requests of the prosecution, it becomes of utmost necessity that all the evidence presented and as part of the testimonies of the witnesses must be carefully examined, scrutinized, identified, and authenticated as much as possible. This is to prevent any technical question that might place in doubt the outcome or verdict of the Senate, and to put on record these questions or how the impeachment court may have decided on these questions in order to perhaps minimize or forestall any judicial remedy that that either side may take later on, and which hopefully will not happen. If you notice, the defense has been repeatedly dropping the fact that there is a pending case before the Supreme Court that it has filed, that the Vice President has filed, and that they have taken the opportunity to remind all of us about the pendency of that case, and that many of the questions raised in this pending petition before the Supreme Court are actually questions regarding veracity, identity, authenticity, genuineness, regularity of the not just the proceedings held by the House of Representatives Committee on Justice, as well as good government and accountability, but also on the documents that were presented to form part of the articles of impeachment. So this is a preemptive measure on the part of the impeachment court in order to prevent such judicial question or to minimize any impact that such judicial remedy may have on the final outcome or verdict. So boring as it may seem or tedious as it may be, it has become of utmost necessity. What I find unnecessary here is the unwillingness of the defense to admit certain documents, even just for the simple fact that they exist. If you notice, if we follow the testimony of State Auditor Attorney Roderick Wamil, and perhaps it will happen again in the testimony of State Auditor Del Ocampo, the defense refuses to admit even the existence of the acknowledgement receipts, which documents have been presented to them at first blush during the pretrial, and to reiterate the manifestation of the prosecution counsel, Attorney Lorna Kapunan, these are the same documents that originated from the office of the Vice President. So I don't really see why they are contesting their own documents that have been submitted first to the COA and later that were procured by the House of Representatives and have been part of the pretrial proceedings before the actual trial began in the impeachment.